I'm Joshua Wurtzel, and I'm a partner at Schlam Stone Dolan. So today we're going to talk about doing direct examination at trial. A lot of people think about trial and you think about the drama of a cross-examination or a closing argument. There's not as much excitement for a lawyer surrounding direct examination. But direct examination is actually one of the most important pieces of the trial. That's the opportunity where your client, your witness, get to tell their side of the story. If you're the plaintiff, it's incredibly important to have a very strong direct examination because you have the burden of proof, and your client needs to be able to explain what happened and why the jury or the judge should find in the plaintiff's favor and should award damages to the plaintiff. And if you're the defendant, direct examination is also incredibly important because you're also going to have a story to tell. When I prep witnesses for direct examination, I tell them that this is their moment to testify in front of the jury. A client shouldn't go to trial thinking that it's going to be some type of cathartic experience, but oftentimes it is. The most important part about a direct examination is to ensure that your witness gets to tell his or her story. It can't seem like you as the lawyer are testifying and the witness is just agreeing with you. Let the witness tell his or her story. There was a judge in the Manhattan Commercial Division before whom I tried a case last year. Separate and apart from the trial itself, this judge made a point to say during a conference that she doesn't like when lawyers just go up and ask yes or no or leading questions of their witness on direct examination. And she said that oftentimes those questions aren't objected to, and the lawyer thinks that he or she is doing a great job. But according to this judge, the jury always knows and understands when the testimony is actually coming from the witness and when it's coming from the lawyer. If you as the lawyer are just standing up there, asking leading questions and leading the witness to where you want the witness to go, the jury's going to pick up on that. I also always tell clients that the best direct examination is when there's a ping-pong back and forth. Witnesses shouldn't be trying to memorize answers or follow an outline. The idea here is that you ask a question and the witness gives typically a short answer. I tell witnesses, typically try to limit your answers to 10 seconds, 15 seconds at the most, unless it's the most critical answer in the case. And the reason that we do this is that the question, answer, that ping pong back and forth, it's a lot easier for a jury, for a judge to follow and to pay attention. And it also shows that you and the witness have a good demeanor between the two of you, because you can just go back and forth and it almost seems more like a conversation. That's better than question and then a long answer, which often feels rehearsed. You also want to instruct your witness that when answering questions, he or she should be turning and looking at and speaking to the jury. Now, during the Johnny Depp Amber Heard trial, Amber Heard was being made fun of a lot for every answer turning and looking to the jury. Maybe she did it too much, maybe she didn't, but that's the right way of testifying. The witness is not testifying to you as the lawyer, the witness is not testifying to the judge, the witness is testifying to the jury. So you need to tell your witness, turn after hearing the question, when you're speaking, when you're testifying, turn and speak to the jury. Look the members of the jury in the eye. You should be having a conversation with them. That's who matters. This is the opportunity for the witness to tell his or her story and to be heard by the jury. And it's good direct examinations that win cases and bad ones that lose them.